Sure you got some water, Grant?
What's that?
You got some water, Grant? Lots of talking.
I do have water, yeah.
The worst part is the golf courses are shut down. Gee, Willikers.
Oh, I know.
Killing me.
I was playing a bit actually when it was kind of in the first phase of this. They had it. The club was shut, but you could just go up there with your bag and play, and maintain your distance, all that stuff. And I was quite enjoying that. It was kind of like the,
Yeah.
Yeah. Well, here.
All right.
Those were the days.
Are you guys ready if I let everybody in?
Yep.
Yep.
Okay, 40 people coming in.
Nice.
Yeah. And they'll all be muted, so no one will
Great.
be interrupting. Okay, here they come.
Hi, Steve.
Awesome. And it connected to Facebook Live. Perfect.
Hi, Steve.
And it connected to Facebook Live. Mike, we've got almost a full house. We're just waiting on, looks like 2 people. Do you want to start her up?
We're at 9:30.
We're at 9:31.
All right. So everybody can everybody hear me? I can't see many pictures. I can't see who's here, Steph. So I'll take it that everybody can hear me. Am I correct?
I see some head nods.
Okay.
Yeah, Mike, we've got almost a full house. We're just waiting on the 2 people. Do you want to?
Okay. I'll assume everybody can hear me. You can use the chat at the bottom there. I see a couple people started doing that. So welcome everybody to our webinar presented by the Tri-City Chamber of Commerce. Thanks everybody for coming out. I know these are interesting and extremely difficult times. It's a challenge for everybody. Nobody's been through this before, so we're all in this together, trying to work our way through this day by day. Things change all the time. I'd just like to say here at the Chamber, we are solely focused on helping business through this. At the beginning here, at the beginning stage where we are right now, we're bringing you educational sessions and keeping you informed as they happen on going-ons in government and policy, etc. We're supporting local business, we're trying to get the word out to support local business, and we will be there when we come out of the end of this, and we will come out of the other side. We will be there to help business get through it. So if you need anything from the Chamber, we're here. We got your back. We're still working. We're a little short-staffed, but we got it going on. So please feel free to email us here at the Chamber, and we'll get back to you as soon as we can, usually within a couple hours if it's during work hours. So thanks everybody for coming out. Again, we're here to help you out. We're here. We're not going anywhere. And the workplace environment right now is an interesting one. Lots of employment issues going on there. So we thought we would bring in the experts. And we've got Catherine and Grant from BTM Lawyers in Port Moody, one of our members here to talk to you about employment law, what's going on in the workplace. And we're going to take your questions at the end of it. They're going to do their session, then we're going to take your questions at the end, and I'll kind of moderate that. But right now, let's get started. I'll turn it over to Catherine to get started. Go ahead, Catherine.
Hey, thanks, Mike, and thanks to the Chamber for having us here. We're definitely had an unprecedented amount of calls and issues because there's no workplace in Canada that hasn't been affected by COVID-19. So Grant and I wanted to provide this information session and then hopefully answer your questions after. We've put together a quick presentation, and I apologize, it's probably not the prettiest PowerPoint you've ever seen. There's a reason we're lawyers and not creatives, so I apologize for that, but we wanted to get as much information to you as possible in as short as amount of time. So today we're going to go over the following topics. We're just going to go over some employment law basics, then deal with the new sick leave protections for workers that the BC government has put in place, and go over both the new and old benefits available for employees and employers that's been announced by both the BC government and federal government over the past few days. Just first, with respect to the employment law basics, the reason that we've wanted to go over this is because there's a lot of misinformation out there and confusion amongst employers about what their rights and obligations are, especially when dealing with layoffs of their employees. The law is not one size fits all. So what might work for Air Canada, which is a federally regulated unionized environment, and then they'll enable them to temporarily lay off their workers without incurring severance obligations, is not going to be the same for your small and medium-sized business that's a provincially regulated here in BC business. For non-unionized employers in BC, the employment relationship is governed by the employment contract, which can be both written and oral. This will cover the main employment issues, which are compensation, hours of work, and wages, and job duties. The Employment Standards Act is a BC legislation that covers the minimum workplace standards and obligations of employers in BC, and the common law, which is judge-made law. There's other acts and regulations that will impact your workplaces, and that will include the Workers' Compensation Act, which is administered by WorkSafe BC, and the Human Rights Code, which is administered by the Human Rights Tribunal. So these are the main legislation for most of the Chamber's employers that will govern what you can and can't do in terms of layoffs. And so I'll let Grant go over what employers here in BC can and can't do when it comes to laying off workers.
Great. Thanks, Catherine, and thanks everyone for coming. We've got about 20 some odd slides, and there's a lot of material here, so we're just going to get right to it. The issues, this temporary layoffs of employees, we find that this is one that's misunderstood by quite a few employers. Temporary layoffs, you probably are not qualified for this. It's a temporary layoff is actually created. It is determined to be a termination of employment, which requires you to pay statutory or common law severance. So there are exceptions to this. It can be if it's in a written employment contract that you contemplated a temporary layoff at some point, then of course you can lay off that person temporarily. Temporary layoff is 13 weeks out of 20, a 20-week period. But the reality is most small and medium-sized businesses don't have employment contracts that are written. And if they do, they don't have employment contracts that contemplate temporary layoffs. Another exception to temporary layoffs is a situation where you're a seasonal employee, so someone that works at a ski hill, obviously they can be laid off, or someone who works in the forestry industry, or there's a few other exceptions. But this is something that we expected the provincial government to change in response to this COVID-19 pandemic. They made changes a couple weeks ago to the BC Employment Standards Act. unfortunately, they didn't change this. So the one other exception is the employee can agree to the layoff. And, you know, we know in small businesses that employees are often, like, it's a family that we have in our businesses, and these employees want everyone to succeed. So they may say, yeah, I'll agree to go on EI, or I'll agree to be laid off for a period of time, you know, but not knowing what the future holds, not knowing if this is going to last 2 weeks, not knowing if it's going to last, you know, 4 months, right? So it's difficult to rely on that oral agreement by the employee because things may change in the future for them. If you do go down the temporary layoff road, and you are only left with the option of having your employees agree, then you know, we suggest that you get it in writing before the layoff, that they do that. And that said, you know, it's unclear whether or not that will be enough, because again, the agreement for the temporary layoff should have been contemplated at the start of the employment. So just moving back to the next slide here. So termination layoff. So, but can I issue an ROE for shortage of work? Issuing an ROE for shortage of work and telling your employees not to come into work, again, is termination of the employment relationship. They don't have to accept that. They, you know, and they can demand severance.
Now, in terms of how severance is calculated, in BC, it's up to both the Employment Standards Act, which sets minimum standards, the floor of notice that you're entitled to, and the common law. If you have a written employment contract that limits termination notice to the Employment Standards Act, that would be all that you're required to provide your employees for severance or notice on termination. But most employers don't have written employment contracts that have a strongly worded termination clause, and so the common law will apply instead. The Employment Standards Act, the minimum notice requirements are 1 week's pay after 3 months of service, 2 weeks pay after 1 year and up to 2 years of service, and then after 3 years of service, it's an additional week per year that you have to pay, up to a maximum of 8 weeks pay for an employee that has 8 years plus of service. If you're a larger employer and terminating 50 plus employees, first of all, you should be getting legal advice before you ever terminate that many of employees at one time. But there are additional notice requirements if you are doing a group termination. So you would have to pay the minimums that are outlined above, plus an additional amount of severance, starting at an additional 8 weeks. So if you had an 8-year employee, you would be paying them at least 16 weeks pay if you're doing a group layoff of 50 plus people. And that can be a combination of working notice and pay. In current climate, it might not be, you might not be able to continue to have them work and then pay them out. And so most often people are paying out severance rather than having a work notice period. If there is no written employment contract with a strict termination clause, severance applies, and it is much more generous towards employees and is not a simple calculation like it is under the Employment Standards Act. Main factors are, again, length of service, the age of the employee, and the ability to find comparable employment. Compensation at common law is also more broad. It includes your wages, bonuses, and benefits that the employee would have received over the notice period. So if you do not have written employment contracts in place, we strongly encourage you to get legal advice before taking any steps to terminate. And that's basically our main giveaway on the employment law basics. If you are contemplating termination, the law is not one size fits all. You may not be entitled to temporarily lay off your employees without having to pay them severance. And it's important to really have your employment contracts reviewed to make sure that they're working to protect both you and your business, and to get advice out throughout the employment relationship. One additional change too, in terms of the new sick leave protections that have been put in place by the BC government. They amended 2 weeks ago the Employment Standards Act to provide unpaid job protected leave to employees that are sick with COVID-19 or in quarantine or self-isolation, advised by their employer not to work due to COVID-19, or able to work because they're caring for minor children or a dependent adult for reasons related to COVID. So this means throughout the entire public health emergency, they are entitled to job protected leave. They cannot be terminated until after the outbreak is over. Once, you know, reopening, schools reopening, if it's they're unable to work because they're caring for a minor child, or advised by their employer that they can come back after in a quarantine or self-isolation. They're not required to be paid, and they are eligible for medical EI during this period of time. And we strongly encourage that employers issue ROEs in this circumstances for illness to help the employees out and make sure that they can get access to as much compensation as possible during that period of time. And Grant's going to take over and discuss the newly announced benefits.
Yeah, so just before I do that, I just want to just go back to severance real quick and say that the Employment Standard Act severance that Catherine went through with the 8-week maximum, that's a minimum requirement by law. So you have to pay that, and then if the employee may be entitled to more through common law severance. So my point is, you may not be done then. You may still be exposed. There may be some liability out there. You know, as I said, get some advice on this, and you know, there may be some strategies that can help you through this. All right, so the newly announced benefits. So you have to register online with CRA, My Account for individuals and My Business Account for businesses. Sign up for direct deposits, both individually and for business accounts, to receive payment as quickly as possible. And who knows how long that'll be, but they're saying it should be in a few days. All right, next slide. Yeah. And so this Canada Emergency Wage Subsidy, this was announced last Friday, and then some details were given on this this week. So employers will receive a wage subsidy of up to 75% of $847 per week per employee that they keep on the payroll. To be eligible for this benefit, you have to demonstrate a 30% reduction in revenues year over year. So that's looking at, as it shows, March 2019 versus March 2020. Now, revenue is a key word here, and how revenue is calculated with your business is, you know, can be quite different. And a lot of businesses are, you know, a restaurant's revenues, it's easy. It's money that they receive for serving the food and the beverages that they do. It's shut down. It's pretty easy to show there's been a reduction. But in a professional setting, like a law firm, for example, our revenues are invoices that we send out. So we may send out X number of invoices or X dollars worth of invoices in March 2020, and it may be that we don't get payment on those invoices until, you know, May. So maybe there's a 60-day lag on that. But that's what the comparable is. So the government's taking a lot of heat on this issue. There may be some changes. Certainly there's changes all the time, but, you know, talk with your accountant and figure out what the mark is here if there's some questions as to what's going to be looked at. As it is now, this benefit's available for 12 weeks for payroll from March 5th. Employees cannot receive the wage subsidy and the CERB. All right, so the wage subsidy as well. So the application for this benefit will be available through the CRA My Business Account portal. Once approved, they say that payments are going to be there within 3 business days. Employers will be required to reapply monthly. And then we've got on here the claiming period that you're able to put your claim in with respect to which month. So for example, if you want to claim for March 2020, your claim needs to be in by April 11th. So, 8 days from now. And then the rest are, self-explanatory as set out below. So a lot to be desired here, but obviously it sounds good, but the details, there's some questions with respect to the details here. I'm sure some of you have them, and we expect that there will be more flexibility coming on this. But like all of us, the government's doing this for the first time, right? So.
Yes, and the government has also announced a new program called the Canada Emergency Response Benefit, which will provide up to $2,000 per month directly to employees, self-employed business owners for a maximum of 4 weeks. And it was initially aimed at individuals that would not otherwise qualify for EI, those being sole proprietors, freelancers, part-time workers, workers without enough insurable hours. It's now being expanded to be available to workers that are also eligible for EI. The work is that during this 4-month period, you'll either get EI or you'll get the Canadian Emergency Response Benefit in terms of payments, whichever is more beneficial for you. And so that will be done automatically when you apply for EI or the Canada Emergency Response Benefit through that the portal that's available on the CRA and websites. They will automatically determine which one is better for you and pay you out on that. For the CRB, the eligibility requirements are that you're a resident of Canada over the age of 15, and you had to have $5,000 of income in 2019 or the past 12 months. You need to have stopped working because of COVID-19. This eligibility requirement is leaving a lot of people out of the protection of this benefit, and those include primarily students that were looking for summer jobs, aren't going to be able to get summer jobs. They won't be eligible for this benefit yet. We expect eligibility to also loosen up over the coming days and weeks. But as of right now, you have to have stopped working because of COVID-19 or stopped receiving income because of COVID-19. And you need to be without employment income for at least 14 days within the initial 4-week period. So, that would be through the whole timeline of the Canada Emergency Benefit. So it's 4 months from March 15th. So if you have within a 14-day period, you lose your job in just the beginning of April, and you don't have income for 14 days, you'll be eligible for this benefit from that point forward. And you have to expect to be without income for the whole benefit period. Individuals who are not eligible are workers who are still receiving employment income, even if it's at reduced hours, workers looking for work or out of work for reasons unrelated to COVID-19, workers who have quit their job voluntarily. Again, the applications can be made directly online, and this is the best way to do it too. And you want to get that online application done even if you haven't lost your job or lost hours yet. It's best to get your MyService account up to date, register for direct deposits to make sure that you can get money in as quickly as possible. They are processing applications at breakneck speed right now, but they've had 1 million applications in the last 2 weeks. So you want to get in there and get your application going as quickly as possible. And so a way that they're speeding this up is that they're requiring, instead of providing a ton of paperwork that gets reviewed by an individual and then that individual decides whether or not you're eligible for the emergency response benefit, they're requiring applicants to give an attestation swearing that they meet the eligibility requirements. So this will be equivalent to giving an oath. And so if it turns out that the information you provided is inaccurate and knowingly inaccurate, you can expect that the CRA will audit you and find out, and you can be subject to a lot of fines, and you don't want to get on the CRA's bad side for this. And so make sure that the information that you're providing in your application is accurate, because you are swearing to that information. If you have applied for EI already before this benefit was announced, and the application is not available yet online too, it's going to be available until April 6th, you will be automatically assessed to see if you qualify for this benefit. And you can receive either this benefit or EI, but not both. So employment insurance regular benefits, these are available for employees that have been laid off or terminated and worked 700 hours in the past 52 weeks. 700 hours for the Greater Vancouver region, the hours of insurable work are based on where you live in the country. So more economically depressed areas of the country require less hours of work in order to be entitled to EI. But for the Greater Vancouver area, it is 700 hours, and that's the same for most metropolitan areas in the country. You can receive up to $573 per week for a maximum of 45 weeks. What they announced yesterday through the Finance Committee is that your entitlement to EI is less than $500 per week. They're going to bump up those people to $500 per week to match the CRB with employment insurance benefits. And that's mainly done to streamline the application process for Service Canada and get money into Canadians' pockets as quickly as possible, and to provide an added benefit to people that would be receiving less on EI than they would through the Canada Emergency Response Benefit. So in order to get and apply for employment insurance, you need to have an ROE issued by your employer for shortage of work or dismissal. Again, online through your My Service Canada account. There's also employment insurance sickness benefits, or medical EI, it's also referred to. And this is available for employees that are unable to work because they are sick, in quarantine, or caring for a loved one who is quarantined and worked 600 hours in the past 52 weeks. It's up to, again, $573 per week for a maximum of 15 weeks, up to $500 per week to match the CRB. And the 1 week waiting period and requirement to have a medical note has been waived. So all you need is your employer to issue an ROE for illness or injury or compassionate leave, and then you apply online through your CRA My Account or My Service Canada account. The BC government has also announced an emergency benefit. It's a one-time payment of $1,000 to BC residents. It'll be available for all residents receiving EI or the CERB. We expect more details to be released about this too. They've been light so far, but we believe it will be administered through CRA My Account, My Service Canada. And so if you get EI or the CERB, you should be expecting the $1,000 benefit. There's also a number of other benefits available to businesses and individuals that have been announced, and we expect more to be announced over the coming days and weeks. And so your lifelines are going to be your accountants and lawyers and financial institutions over the next few weeks. So keep calling them and asking them what benefits are available for you, because there's going to be more and more coming out every day. One that has been announced by the federal government is the Business Credit Availability Program and Canada Emergency Account. It's offering businesses loans of up to $40,000 with up to $10,000 being forgivable. Very few details on this. contact your financial institution to determine whether you're eligible for this. There's also tax deferrals that are available for businesses, deferring GST, PST, and school tax until payment until September 30th, 2020. The BC government's also announced a reduction in the school tax of 50% for those listed commercial properties. There's, for individuals, increased Canada Child Benefits, GST tax credit, and BC Climate Action tax credit. BC Hydro and ICBC have also announced a number of relief programs and mortgage and consumer loan deferral programs. Those depend on a case-by-case basis with your financial institutions. So we recommend that you contact your financial institutions to inquire whether you qualify for those programs. That's our presentation now. So we're ready and able to take questions.
That's great. Thank you very much, Catherine and Grant. That's fantastic information. I will say that this is changing daily. I'm on a call every morning with the federal government, and they're right with the ministry in Ottawa, and we get updates every morning. And I can say they're hearing the questions we're asking, that you're asking, and some of them you're asking here. They do not have all the answers. This is all new to them, so they're going along trying to make adjustments as they go based on the feedback we give them through the chamber and the chamber network. And I can tell you the chamber network is being heard very loudly. So keep the feedback coming. We'll keep the questions going into them. I'm getting questions on other things other than this, credit card fees and stuff that I'm firing off them too. But let's focus on right now what we've got here. So I'll ask the questions, and Grant or Catherine can answer them. I'll go through them. I'll try to get some really quickly here, some easy ones. Steph, just hang on one second. I saw a couple here. Does self-employed who individually or professionally incorporated qualify for CERB?
They should qualify if they can, but they have to have no income according to the new qualifications right now. But the application actually hasn't been produced yet, and it's coming on the 6th. And so we should know by Monday, but they haven't said that self-employed people and incorporated businesses will qualify for that benefit.
Yeah, my understanding is they will qualify for that, but they're still working out the final details on that. When you issue an ROE for an employee due to being off ill as a result of COVID-19, do you have to issue a note on that ROE?
By note, they mean medical note or any information? You just have to issue the ROE. So you would just put, you have to put information about what their payroll was over that to make sure that they have the 600 hours of insurable service to be entitled to medical EI. But it's the employer's obligation is just to issue the medical ROE. Okay. And best to do that online as well, if you can.
Yeah, I don't think you need to be, and my understanding is you don't need to put a note in there. They all, and this time they're kind of assuming most people are laid off because of COVID. So if you want to bring back, where we go here, if you want to bring back an employee who agreed to a temporary layoff, what is the process? Does a new agreement need to be signed by the employee, and what should it say? A little complicated, that one.
Yeah, so I mean, I guess it depends if you had an agreement with them before. You know, if you didn't have an agreement with them before, then it would be a good time to get an agreement in place that would help your business. You know, it really would depend on the circumstances, but you know, someone who's been temporarily laid off that wants to come back to work at this time, or you know, in the next few weeks, that you know, that certainly can happen, right?
Yeah, I think on that one, you need to, if you didn't have an agreement before and you want one now, you probably need to seek some legal advice.
Yeah, the bottom line is every employee should have a written employment agreement that has termination clauses in it. As simple as that. You know, if we have to terminate you, or if we have to temporarily lay you off, this is what is going to happen. That gives all of you certainty as to what your costs will be in the case of if you're trying to sell your business, the new purchaser understands, you know, what the severance obligations are. I mean, there's so many benefits to it.
Yeah, it's the gold standard.
Get employment agreements. They don't have to be long. They don't have to be complicated, but they should be there.
Great advice. Nick is asking, what about the section of the Employee Standards Act that might apply to relieve the requirement for termination notice or pay for some businesses impacted by COVID-19? Interesting.
Yeah, I saw that question, Nick, and that's a very good question. And there's another question on force majeure that was put up by who was that put up the force majeure question? Michelle. So these are really in the same. Force majeure is an act of God, and a lot of contracts have force majeure contract clauses that essentially say, you know, the contract's no longer applicable if there's a force majeure or there's an out clause of a force majeure. You know, obviously there's a lot of, it depends whose side you're on these things. If you're an employee that's been temporarily laid off and eventually doesn't get their job back because this goes on for a long time, their opinion may be different as to whether or not this is, you know, it was impossible to perform this or this was an unforeseen event. As an employer, you know, it really depends. I mean, if you have to lay off your entire, if you have to shut your business down, that's one thing. But if you're, you know, getting rid of your least favorite employees through this and trying to rely on 65(1)(d), you know, you probably won't be successful. So it really depends on the situation. I don't know, Catherine, if you have anything else to add to that.
Yeah, and with respect to force majeure, you can't contract out of the Employment Standards Act. You are obligated as an employer to pay that notice, regardless of why your business goes under or you have no longer any business in place or no revenues. That's an obligation that the employer has. So you want to keep, in terms of that section, you have to meet the very strict requirements to have that section be in place and applicable to you. And it's really industry specific. It's not a broad protection for employers laying off. So recommend that you get legal advice before doing that, just to make sure that you actually meet those requirements.
Yeah, and we were expecting our government to come out, the provincial government to come out and give some clarity and relief to small businesses on this exact issue, and explain, you know, or expand that that section of the act to allow employers to deal with this issue of temporary layoffs without incurring the liabilities of severance. But you know, right now they haven't done anything. Would be a great thing to get in touch with your MLA about.
Yeah, because a lot of you don't want to sever that relationship either. And so it puts you in a very difficult position when both the employee and the employer understand that obviously coming in, there's no work to be done, that we need to have this period where we're all at home. If you're not an essential service provider, you should be operating in the same way that you would before, but not that flexibility baked into the Employment Standards Act that for this type of situation. And so you expect the law to change, and we expect the case law to be a bit different following this COVID-19, and COVID-19 cases will be presenting for employment law, but we're just not in that period of time right now where we have that flexibility for employers.
Employees need to exhaust sick and vacation pay prior to applying for CERB.
There's nothing that says that they have to do that at this stage. Nothing in the requirements say that you have to be paid out your vacation pay or sick leave for qualifying it. It's just regular wages.
Okay. And do self-employed who individually professionally incorporated qualify for CERB?
Yes, you should qualify. What it looks like for you when you're applying is unclear right now because the application process hasn't been put on the Canada Revenue website. What they're really looking at, I think, in what they're doing to streamline the process is focusing on those attestations. And so if you're an incorporated business and you still have some revenues coming in, you may want to make that clear in your application of that is for previous work, so that you make sure that you're being as forthright with the CRA as possible when you're making that application, but you should qualify.
Well, that question comes up quite a bit on my phone calls every morning with Ottawa, and the answer I keep getting is they think so, but they're still trying to work out the details. So I say stay tuned on that one early next week, and we'll get the information out as soon as we get it too. Can you apply for CERB and transition into wage subsidy, or do you have to complete the first 4 months of CERB?
So you can only get one, wage subsidy or CERB. And they're both, different people are applying for both. So it's the employer that would be applying for the wage subsidy for their employees. And it is more generous. And if you qualify as an employer and you want to keep your employees on payroll, that's the best way to go, is the wage subsidy, because it is more generous than the CERB. But you can only get one or the other. If you're an employer that simply can't make payroll anymore and you need to lay off your workforce, and you don't qualify for regular EI, it would be the emergency response benefit that would be available for your employees.
Okay, and another one is
contractors.
I've seen a couple questions here about not being in business for a year, so no comparables to the year before.
Yeah.
My belief is they're still working. They know that's an issue, and they're trying to come up with a solution to that, and that'll be announced early next week too, hopefully.
Yeah,
so,
that's right. That's right. That's exactly it. Yeah, you can't compare year over year if you haven't been in business, right? So you're going to have to come up with a solution to that issue.
And it's the same if you're a startup that's been working on capital, finally getting some revenues in now, you're going to look like you're in a better place in March 2020 than you were in March 2019. So there's a lot of areas left to be desired that the federal government is going to have to work out for that.
Okay, what else we got here? Self-employed people. Self-employed who collect a dividend, do they qualify, meet the requirement for CRB? I believe that answer is coming. I think so, but the definite answer is coming next week.
Yes, they should.
They should, yeah, and I know the government's aware of it. They're just, again, they're trying to figure it out. Many employees have been laid off before information came out, as we were told to use code A or code K in the ROE. Now you are telling us those automatically be considered termination, i.e. severance, even if the no reason for COVID was entered into the temporary layoff.
1 sec. Many employees have been laid off.
From Anita at 10:03.
Yeah, I'm looking. 10:01, is it? 10:01?
10:03. A little bit down. What code should they put in there for laying off? Or for
The issue is, the ROE governs employment insurance. It doesn't govern the employment relationship. And so if if your employee agrees to a temporary layoff in writing, you can, as long as it's that 13-week period, you will be able to, it's only 13 weeks that they're temporarily laid off. That's your best protection against having to pay severance. But the ROE itself doesn't govern the employment relationship. But if you do say shortage of work, don't come in to work, we're not going to pay you anymore, that would be considered a termination of the employment relationship, entitling an employee to severance. So they don't have to agree to the temporary layoff in that situation, unless it was in their contract prior to the COVID outbreak.
I mean, are you, I'm not sure if the question is, are you wrong to take the position that this is a temporary layoff? Maybe perhaps the employee agreed to it. I see Fatima right before Anita asked that question. If they agreed to the temporary layoff, you have that in writing. You know, you don't pay them severance. You took the position at 65 1D applies. You know, that's an interesting position to take, and you know, it might not be wrong. I don't think we can say for every circumstance that that's correct. I don't know, Catherine, if you have any views on that.
Yeah, it will depend on the very specific cases of your industry and employment relationship. But for most people, it probably wouldn't work.
There's also questions about reducing hours, and there's one here about if you reduce hours, do you have to produce an ROE and severance? And I think there's a couple other questions about reducing hours. I don't think an ROE is required if you reduce hours because they're still employed. Is that correct?
Yes, you wouldn't be producing a ROE for reduced hours. At law, a reduction of hours and a reduction of pay unilaterally from an employer to an employee could be considered a constructive dismissal of the employment relationship. Obviously, we're in unprecedented time here, and how the court will view that in the future will probably be a bit more favorable to employers than they have in the past. In the past, if you reduced hours of your workers unilaterally and reduce their pay, then they would be entitled to say that their employment was constructively dismissed and they would be entitled to severance. But they would also have an obligation to mitigate their loss of employment by continuing to work those reduced hours. So it basically makes it a nullity. And the only potential liability would be for the amount that you're not paying them, the reduced hours. But it's something that should be, again, reviewed on a case-by-case basis.
I guess some of the businesses I were hearing from were like, okay, so my employee, if I reduce their hours way down, they're better off going on the wage, getting the CREB that are working for me. So, and if they go on it, they might not want to come back right away, type thing, as a gradual open. So there's things floating around about that, and there's a question here about any idea if CREB can be prorated or partial pay benefits if the self-employed income has not gone to zero. So I don't hear any talk about prorating at all. Do you?
I've seen the current website guidance from Service Canada is that it has to be, you can't be just reduced hours. It needs to be no income. We expect there to be flexibility in the future for that.
And a question from Facebook, what if your employees are commission-based? Can they still qualify for the 75% wage subsidy?
Yes, they should be able to.
And
You just have to show that revenue reduction, which, you know, commission, it almost makes it easier than non-commission based business.
Yeah. And if I was working until April 1st, can I apply for CERB?
Yes.
Okay. Anything else here? Did I miss something, Stephanie? Let me know. Type in there bottom if anybody got anything else I missed. Anything that's outstanding out there. No, it's a new one. How will the wage subsidy payout be distributed?
So it's per employee and it will be distributed to the business. So the business has an obligation and they've sort of they're cracking down on businesses to make sure that they are appropriately providing wages, that wage subsidy to the employee. So we expect that there will be a lot of audits in the coming years of businesses that received that wage subsidy to make sure that they were accurately reporting the revenue decrease and that the benefits did flow to the employees. And they're encouraging employers to top up the remaining 25% of the pay that they will be receiving.
Yeah.
Sure.
And the other question is, how will CRA look at this wage subsidy? I've heard that they're going to be considering this as corporate income. So, you know, that'll have another effect on you know, really what is this? How much are you given?
Yes, and it's not clear too whether it's going to be taxable in the hands of the employee either.
Aaron's asked if an employee went on medical EI for 2 weeks selectively, will 1 week waiting period be automatically waived, or do they have to call a number to get this 1 week period waived?
It should be, it's automatic. I believe the date was March 15th, but it would have been middle of March. So if they've applied after the middle of March, it would be automatic.
Okay.
Automatically waived.
And I guess Steve somewhere has asked a question. I'm sorry, Steve, I didn't see it, but Leanne's re-asking regarding someone refusing to work due to fear of COVID-19. How do you handle that situation?
Yeah, that's a very tricky, especially for essential service providers right now. I would make sure that you're following the guidelines set out by the BC CDC and WorkSafe BC for your individual workspace and workplace. I
mean, the provincial government said it's like, it's going to be, you can't really terminate someone as a result of COVID, right? So if they feel they need to self-isolate or whatever, you know, they have fear or anxiety or something like that, I think it's going to be a pretty difficult position to be successful on if you want to, you know, take action on that person. But it's, you know, they can go off without pay and go on medical EI if that's what they want.
Yeah, that would be the safest bet, to issue an ROE for medical EI.
Okay, then Kenny asked, I heard that CREB is only good for 4 months, then the regular EI kicks in. Is that true? I don't think anybody, like, who knows how long this is going to go on. I think the government's just playing it for the next 3 months and 3 or 4 months, and then we'll re-examine.
So if you have been laid off and given an ROE, it's best to just apply for EI right now before even the application for CRB goes into place on Monday. The reason for that is it gets you ahead of the line and you're automatically assessed for the CERB. And so you'll get the greater of the EI or the CERB for those 4 months. And then balance can be EI after that if it's not extended. Like they're probably going to be extending the CERB if it goes on further. And so if it just depends on what wage you're at when you apply for that you had for EI, whether the CERB is more benefit for you or not. But
Okay.
you will qualify for either and get the higher of.
Okay, trying to keep up with the questions here on the one from Facebook. If a person is working reduced hours and I want to apply for the emergency wage subsidy, will that person continue working or has to stop working to receive the payment? No, they got to, keep working.
Yeah.
Yeah. Yeah. Is the emergency wage subsidy available for the company that pays the salary to the owner and there is no other employee, self-employed essentially, I guess? Yeah, we believe it is, but again, more details are coming out early next week on that. My read on it.
Mm-hmm. And even for that, sorry for that question about reduced hours and the subsidy, as long as you're continuing to pay the employee at least the 75%, you can get the wage subsidy. They don't have to be actively working. They just have to be not laid off on EI or the CERB.
There's questions about the wage subsidy with hourly workers. How does this work? Even if open, we would be at a total loss. And there's another one. If our business has zero income coming in right now, the wage subsidy doesn't work for us, correct?
Yes.
Well,
yeah, that's the downfall of the wage subsidy is it requires you to have some money in the bank to pay your employees in order to get the wage subsidy.
mm-hmm.
So in that case, it might be more beneficial to go on the CERB.
And Anita again asks, the ROE web page main says specifically, if your employees are directly affected by COVID-19 and they are no longer working, you must issue an ROE. It also tells us we must use code A. Only code D is if sickness quarantine. So it must use code A. Essentially, they're forcing us to lay off.
Yes, that's why we were expecting the BC government to amend the Employment Standards Act to broaden the categories for temporary layoffs.
So if you've laid somebody off already and you want to bring them back to get the subsidy, so if you laid them off and terminated the employment, but you want to bring them back, do so under a new agreement?
It's all a negotiation and dialogue with your employees too. So if they agree to come back, you at that point may want to put in a written contract if you didn't have one in place. But if they agree to come back and rather have the wage subsidy, then that's totally something that you can do and access.
All right, what else have we got here?
Yeah, I mean the severance, the layoff, the temporary layoff situation is a problem that I know a lot of people are wrestling with, and you know, it's for a lot of employees, and I know and everyone wants to do the right thing and follow the law, and you should, of course. And the law, you know, subject to Section 65(1)(d), says that you need to pay the termination as set out in the Act. You know, that, like, if you have the funds, that's what you should do. You know, once you talk it out with your lawyer or your business partners and make your decisions as you need to. But you know, if you don't have the funds, like if your business is completely shut down, you can't pay them, and they're on employment insurance, you know, right away with no waiting period. So they're getting a percentage of their salary right away. You know, what may happen, you know, they may put a claim in, you know, against you, and you'll have to deal with that as you go down the line. But as it stands, I mean, it's just the uncertainty as to what to do there is difficult. And if you take, you know, the position that we think is probably the safest position to take, which is to pay them the statutory minimum, you know, then that delays them getting their EI for the time that you've paid them as well. So if you pay someone 4 weeks statutory minimum severance, you know, they don't collect EI during that time, and that's a difficult position to put our employers in this province in, and you know, that's why we want clarity on that. You know, it's difficult, and it can be very expensive, and so it's, yeah, I don't know, Catherine, if you have anything to add to that.
Yeah, it's just that you got to think of the employment insurance regime as being separate from the employment relationship. And so you do have an obligation to issue those ROEs, but by issuing them, in some ways, and not paying your workers their regular wages and salary, and not having them come into work, you're effectively terminating them unless you fall under those very strict guidelines for temporary layoffs in the Employment Standards Act.
And what do you think?
Little flexibility.
What do you think if your employees, Catherine, would sign a agreement for a temporary layoff?
I think if they agree to it, that is what, you know, is in your best interest, and to do it in writing. So at least you have that protection. Whether the Employment Standards Branch will still determine you have an obligation to pay those minimum amounts is yet to be seen. But that would be the safest bet, is to give them the choice of, okay, we'll temporarily lay you off. If you agree to this in writing, that'll get you EI in your pocket right now, and call you back once business is back and running. Or you have the option of being paid out severance. So giving them that choice of is probably the safest bet going forward. But we are in uncharted territory here.
Couple quick questions here. We're getting questions about benefits, and A, can you continue to pay benefits while they're off? And B, can I reduce costs by discontinuing benefits or cutting them back? Can you continue while they're temporarily laid off? What about benefits?
So for benefits, if you're taking the position that it's a true temporary layoff, you intend to rehire these workers, have them come back, and you don't want to pay severance, cutting off the benefits is not a good idea. You got to keep those benefits going and keep paying for them if you're going to take the position that you have the right to temporarily lay off your workers. If you stop paying the benefits, then that gives more an indication that that's a true termination of the employment relationship. There's some benefits that they won't qualify while they're not actively working and employed, and that's usually your short-term and long-term disability. So you want to connect with your benefit provider to see whether your employees still have that coverage during periods of temporary layoff. It's important for people to know too if they have to access short-term or long-term disability plans.
I think that covers most everything. We're at time. So a couple things. Thank you very much, Catherine Grant. It was great information. This is it's a level, there's a lot of uncertainty out there right now, and the government tends to, well, they make these announcements politically to ease people's minds a little bit, but they haven't worked out the details behind the scenes yet. And there's a lag. And that's where we get caught up with all these questions. The politicians will make the announcements, and then the civil servants have to figure it all out. And that's what we're going through right now. So stay tuned. The chamber and through our partners and through our information, we'll get you the information as quick as we can. We may do another one of these. May ask Catherine and Grant to come back in a week or two and update on where we're at, because there's a ton of good information there. If you got any questions, can they contact you guys? I know, Catherine, you guys have put it out there on Twitter, and we put it out there on social media to contact you if they got any questions.
Yes, of course, we're happy to help and help serve the community. We know it's a stressful time for everyone, so Grant and I are happy to take any questions that you have.
Okay.
Yeah.
Go ahead, Grant.
So just on that, we've been doing free clinics on telephone or Zoom clinics on Wednesdays between 1 and 4. If you want to take part in that, it's a 30-minute telephone consult. We'll do our best to help you out. And that's really a lot of simpler issues on that. If it's a more in-depth, complicated issue, which there are a lot of those out there, give us a call. Again, our number, or you can Google us. We're obviously on the web, 604-937-1166. Give us a call. Book a 30-minute telephone consult. Either Catherine or I'll chat with you and try and help you through some of this stuff.
And Steph, can you post that contact info on the chat room there so they can, yeah, perfect. There we go. It's up there now. There's the phone number there. So
yeah. So what we need on that is we need your business name, and if it's with a particular employee, we need that name of that employee, just so we can run a conflict search before we can speak with you about it. So you have to speak with our receptionist, Carol, and she'll help you out.
Okay, cool. Well, thank you very much. Couple things just to update everybody. On Tuesday at 4 o'clock, we're going to do a chamber kind of roundtable where the chamber's at, listen to you. So anybody can come on a Zoom meeting. We want to hear what's going on, and we'll update you what we're doing through all this, and we want to hear from everybody. So please feel free to jump in on that. Wednesday at 11 a.m. we're doing a webinar with Rise Advisors on business continuity. We're trying to help you through this, so read that. And Thursday, Angela Cowell is going to do a webinar on mortgages and what's going on in the mortgage scene right now. So please be aware of all that. We've got daily emails going out. We're updating you as quickly as we get the information, and we get it very quickly. We do have our connections into the various offices at the federal and provincial level, and I can tell you the BC Chamber is tied right into the finance minister and the premier's office on a bi-weekly basis, and we feed information to them. And I'm talking to our MLAs and our MPs all the time. So working together, we will get through this. It's not going to be easy. but we will be here to help you all the time, all the way. So please let us know if you got any questions, any concerns, any issues that you think that need addressed. And I've got about 3 emails this morning from people about various different issues that I got to run up the flagpole at the various levels. So thanks, everybody. Thanks, Catherine. Thanks, Grant. Thanks, BTM Lawyers, great partners. Have a great weekend, and please let us know how we can help you, and stay strong, everybody, and stay safe. Bye.
Bye.